I've been closely following this case since the very beginning. I guess it was like November 2012 when Eli Lilly first filed the notice of intent. And since then, I read everything about the Canadian law. And I'm becoming a Canadian law expert, although I'm not from Canada. And people are asking me why I'm like obsessed with this case. Like, you are not Canadian.
And as a Canadian, one thing I find is that people get us confused with Americans.
And I don't have a Canadian accent. My accent is not Canadian. But I do care about access to medicines. You know, we are a global access to medicines program, and we promote access to medicines, especially in developing countries. And we promote like countries' use of flexibilities. And this case is important for us. This case is important for us for three reasons. There are three issues relevant to us in this case. First of all, patents, health, and innovation. And expanding pharmaceutical monopoly power compromises access to affordable medicines. We have too many patents. And as if we don't have enough, we now have the secondary patents. And that's a serious problem for access to medicines policies. And the second issue for us is the patentability standards. TRIPS agreement. We love TRIPS agreement. And we want countries to use their flexibilities in TRIPS agreement. And for us, promise of the patent, or the promise doctrine as it's called, is the TRIPS flexibility, because the TRIPS provides you the frame. And it's up to countries to implement the patentability criteria, patentability requirements. So this is important. This case is important because investor-state dispute settlement is a new venue for us. There is a jungle out there, and we patent lawyers, we don't know much about this investor-state dispute resolution. And it's a new venue to challenge the government's and the court's decisions like on access to medicines and access to medicine policies. So we are very, very concerned about this case. Okay, before I start with all the issues, I'm delving into the details. I just want to set the foundations. And what is patent? I think there is a confusion about what is patent because people are talking about usefulness, but they confuse patent usefulness and the real life usefulness. So what is patent? Patent is a negative right. Patent is not a positive right. Patent grants patent provides the inventor to exclude others to use, to market, to sell the invention. It doesn't give the inventor to sell or to market or practice the invention. And this is an important distinction for us to remember, because when we talk about patent, we talk about patent bargain. So as society, every time we grant patents, we sign a contract with the inventor. We tell the inventor, look, you're revealing your invention, and we'll give you this 20 years exclusivity so that we can learn from your invention, but you have to disclose. That's why disclosure becomes important for patent law and policy. So, coming back to our issues, secondary patents. When you deal with like global access to medicines, when you promote like access to medicine policies, you fight against patents. It's not that we don't like patents, but there are too many of them, and not necessarily they are not necessarily the strong ones. So there are too many weak patents out there. And lately, we've been experiencing this problem with the secondary patents. What are secondary patents? Secondary patents are usually directed to new developments or improvements of the subject matter of the basic patent. And according to a recent study from Kempinski, Park, and Sambat, there were like 528 new molecular entities approved by the FDA in between 1988 and 2005. And 51% of them covered the new forms of known substances. And in 81% of them, there were claims covering method of treatment or use claims, so-called secondary claims. So we have problems with secondary patents because they create like so-called evergreening. And evergreening allows pharmaceutical companies to extend monopoly protection and potentially indefinitely, because they get patents on everything. yeah, I added a salt. Now this is a new patent. This is a new form. This is a new patent. This is the second use patent. This is a new patent. So it compromises affordable access to medicines. So coming back to our issues. Number 2, patentability standards. TRIPS agreement. We all believe in TRIPS agreement. And we want countries to use their flexibilities in TRIPS agreement. And one of the most important flexibilities in TRIPS agreement is Article 27. Article 27 sets the criteria for requirements for the patentability. It says that patents should be available for any invention, provided that they are new, they involve an inventive step and capable of industrial application. But it doesn't provide further guidance, leaves it up to countries to how to implement it. So we have 3 requirements: novelty, inventive step, industrial application or utility, because there is a footnote in Article 27 which says that countries may deem like industrial application and utility synonymous. But this doesn't mean that they are same, because they have different functions. Utility is a North American criteria for patentability. It determines the general patentability, but utility has another function. It determines the completion of invention. Remember the patent bargain. Us, society, we give these patents, we grant these patents, and there is this bargain between us and the inventor. And we expect inventor to complete his invention when he applies for the patent. So disclosure becomes important. Disclosure lies in the heart and origin of the patent law. And as public, as society, we are entitled to receive the best disclosure. And we want inventor to know whether his invention will work or not. We don't want a speculation, because that's the foundation of the patent law. Having said that, Andrew summarized the Canadian law, but I just want to add a couple of more comments. So utility. Canada has a utility standard. Canada's utility standard is a little bit different than the US standard, because Canada has had like first to file system since the very beginning. So the things are work differently in Canada. So when we talk about utility, Canadian law requires utility to be demonstrated, because there is a contract theory, there is patent bargain. So the inventor should be able to demonstrate the utility. But what if he can't? So don't worry, Canadian Supreme Court took care of it. And so they introduced this sound prediction test. Sound prediction test is not something bad for the inventors or the pharmaceutical companies. It makes it easier for the companies, because if they are not able to demonstrate the utility, they can rely on this test. And what are the requirements of this text? A factual basis for the prediction, a sound line of reasoning, and a proper disclosure. Not much to ask for 20 years of exclusivity. So, and of course, the foundations of this promise can be found in all British law. This is a House of Lords decision. So, coming back to the Eli Lilly cases, and let's see what all the fuss is about. Andrew, he summarized everything, but I want to talk and I want to give you my perspective on this case. So, Strattera. The active ingredient of Strattera is atomoxetin. Atomoxetin is invented in 1979 and is patented at that time. So 20 years of exclusivity. The inventor received the exclusivity. He disclosed his invention. And just before the patent expired, they repurposed the drug and filed a new application for the 20 years extra exclusivity. So, and they said that this drug is good for the ADHD. You know, this drug will treat ADHD. What is ADHD? ADHD is a chronic disorder. It's a lifelong disorder. So, and when the when Eli Lilly filed the Canadian generic companies for infringement, the court asked two questions. Was there a sufficient evidence demonstrating that at the time of filing, atomoxetine would do what the patent promised, treat a chronic disease, chronic disorder? And then they also ask a second question. What has Lilly given to the public in exchange for the grant of the monopoly? Unfortunately, Eli Lilly didn't give anything but a 22-patient study to the public for the exchange of 20 years of exclusivity. So what they submitted was like, they didn't even submit, but they mentioned this study. It's like a 6 weeks long, 22-patient study. So this is what society received in exchange of 20 years. Of course, the court said that, we are sorry, but this is not how patent system works. You ask for additional 20 years, and the only thing you provide us was like a 6 weeks study for a chronic disorder. So they invalidate the patent. The second case is more interesting because Zyprexa active ingredient is olanzapine. And it is discovered in 1980 and patented as a part of large class of compounds for the antipsychotic drugs. And then just before the patent expires, Eli Lilly was like, what should we do? We have a great market share for this drug and we need to extend our monopoly. So as the court says, as the sun began to set on the first patent, they need to find a way to extend the patent monopoly. And this is a typical evergreening example. So they selected the compound olanzapine and ran to the patent office and they were like, this olanzapine, this works better than the previous compound because it has superiority over the larger compounds and a better side effect profile. So, of course, the court asked, yeah, these are great statements. Show us, demonstrate us. Why should we give 20 years extra exclusivity for this drug? But the patent specification included forward-looking statements without any factual basis. So the court and the judge said that this is almost an invention. Not nearly there, but almost an invention. But we are sorry, we are not going to give you 20 years extra exclusivity for this drug. So, and then Eli Lilly tried to go up to Supreme Court and challenge the decisions of the Canadian Federal Court, and the Supreme Court denied the leave of appeal, and we ended up the NAFTA arbitration case. Welcome to the jungle. So, according to the Eli Lilly's notice of intent, Canadian application of so-called promise doctrine or the promise of patent or the utility standard infringes the patentability requirements enshrined in NAFTA. So when I first read the notice of arbitration, I was like, patentability requirements enshrined in NAFTA? What are those requirements? Why do I don't know anything about these requirements? So I checked the article, and I was like, this looks very familiar. This is exactly the same as or TRIPS Article 27, because the NAFTA Article 1709 was based on the Dunkel draft of the TRIPS Article 27, which then became the final text of the TRIPS. So how we read TRIPS? We love Article 27 because we think that there are flexibilities there. It sets the criteria for patentability, but leaves it up to countries to come up with their own standards and implement it. And it's up to countries how to implement these requirements. So, and then I checked the literature. I was like, maybe I'm missing something. You know, maybe NAFTA has like some kind of like patentability requirements. And then we don't know about that. But in literature, it says that NAFTA and TRIPS generally coincide with each other. So, and when you go for the interpretation of FTA, you can also rely on the other rules in international law, such as Vienna Convention. And according to the Vienna Convention, a special meaning shall be given to a term if it is established that the party is so intended. And when you look at the NAFTA, there is no intention. So it's really hard to talk about infringement of NAFTA or infringement of patentability standards enshrined in NAFTA. But then Elarli claims, actually this is also the infringement of PCT, Patent Cooperation Treaty. So what is Patent Cooperation Treaty? Patent Cooperation Treaty just deals with the matters of form or contents required for international application. There is nothing in PCT which deals with the matter of substance. And what we deal here is a substantive matter, because we are dealing with like the utility and disclosure of that. So this is a substantive matter, and there is even a provision in PCT. We said that members have freedom to prescribe substantive conditions of patentability. So, coming back to our three issues. Why this case is important for us? We are not Canadians, but we care about this case. First of all, patents, health, and innovation. We have too many of patents, and expanding pharmaceutical monopoly power compromises access to medicines. And we have to find ways to deal with secondary patent problem, because more patenting doesn't necessarily mean more innovation. And as a society, we should be able to find solution to this secondary use patent problem. And the patentability standards. We promote TRIPS agreement. We promote countries using their flexibilities in TRIPS agreements. And we are concerned about the chilling effect, because this is a warning for the other countries. Don't ever mess with our patents. You will end up in investor-state arbitration. So that's the issue. This is a new venue. This is a forum shifting for us. And now, as if we don't have enough problems, we have to deal with ISDS. Thank you very much.